Welcome to Business Law 1 class. Today look at Section 3 of Unit 6, Breach of Duty and Defense Against Negligence. By the end of this session, you should be able to understand the concept or standard of care as prescribed by the court and the components of the various standards. Let's now consider breach of duty of care. When do you say a person or the defendant has breached his or her duty of care? Now, the issue that you have to address in that regard is whether or not the actions of the defendants were sufficient to meet their duty. So what test will you use to address this particular issue that has been raised? The test is the reasonable person's standard or the reasonable person's test. Now, this test simply means that what would a reasonable person in the shoes of the defendant do based on the surrounding circumstance? In other words, if you put a reasonable man in the circumstance that the defendant acted, would that reasonable person act in the same manner? If the answer is yes, then the defendant has not breached any of it, the only duty of care. If the answer is no, then the defendant has breached his duty of care. So a reasonable person is not any person walking on the streets. If you're a professional accountant, then if you breach your duty of care towards your client, then the court will look at it. A reasonable person, being a similar accountant like you, would a person perform the same, or would a person act the same way you acted? If yes, then you have not breached any obligation or any duty of care. If no, then you have breached a duty of care. That's what we mean by the reasonable man's test. Now let's consider the Latin maxim, res ipsa locutu. This res ipsa locutu simply means that the matter speaks for itself, or the fact speaks for itself. So the fact speaks for themselves, or the fact speaks for itself. Now, you will only evoke this principle when the defendant have control over the situation, and the incident wouldn't have occurred if the defendant had taken proper care of the situation. And lastly, the defendant has failed to give reasonable explanation as why the event occurred. Now, before you can evoke the Latin maxim res ipsa locutu, you have to point out that the defendant had control over the situation. Also, you also have to point that that incident wouldn't have happened if the defendant had taken proper care, and the defendant had failed to give explanation as how the event happened. Then you evoke the principle of res ipsa locutu, meaning on the part of the case, it is clear that the defendant is negligent, or the defendant has breached his duty of care. Now, when there's a breach, there's going to be loss or damage. How do you determine that this damage can be recovered from the defendant? Now, what you have to do is that you use what you call but-for test. Is the damage or loss too remote? Remember, if it is too remote, the person cannot recover those losses. Now, before you can ascertain that, you have to use but-for test. But-for test means that the action or the losses would not have occurred but for the defendant's negligence. or but for the defendant's breach of duty of care. Let me take it again. This is how you use the but for test. The incident or the loss wouldn't have occurred but for the negligent act of the defendant or but for the breach of the defendant's duty of care. That's why the accident or the losses have what? Occurred. Now, you should also understand that sometimes there could be possibility that more than one causes will contribute to the losses. So how do you determine who is responsible? So the principle states that where there's more than one possible cause of the loss or damage, the defendant will only be liable if it can be proved that his actions are the most likely cause. So you have two events causing the injury or the losses. Now, if you can prove that it was the defendant's act that is more likely than not to cause that loss, then the defendant will be liable. And the case in question is Bennett v. Chelsea and Kensington, HMC. So you will read this case and you get more insight into the facts. Now, you can also raise the defense of novus actus intervenis. This defense simply means that there was an unintervened event that caused the losses. Simply put that even though the defendant started the action, but it was not the defendant's act that caused the losses or the damage. So we explain a Latin term for an intervening unforeseeable event that occurs after the defendant's negligent act and operates to precipitate or worsen the plaintiff's loss. As I was explaining, the defendant might have started the whole process, that his negligent act, but something that he didn't think of may intervene to cause the loss of the plaintiff. In this case, the defendant will be absolved from such losses. What means that the defendant will not be liable for those losses because it is not the negligent act of the defendant, but that unforeseen event or circumstance caused the injury. So the defendant will not be liable. Another defense is the issue of voluntary non-fit injury. It simply means that you voluntarily assume the risk. Assuming that you want to buy a car from someone, the person say, oh, this car, the engine is no good. But he said, oh, I like it like that. Once you finish the agreement and you purchase and make payment, and you go and you face challenges as far as the engine is concerned, you cannot bring the item or the car back because you were aware of the fault of the injury, yet you went ahead to purchase the car. So when we bring it in football sense, for instance, spectators who is hit by a ball while sitting in a stand as a soccer, that person has taken the risk, because when you get there, there's possibility that you'll be hit by ball. That's not to say that someone should intentionally hit the spectators by the ball. You also have contributory negligence. Contributory negligence takes place where by saying that even though the defendant caused the injury or the losses, but the plaintiff also contributed to those losses. For instance, your friend wants to give you a lift. You are aware that your friend is drunk. Ordinarily, if you are drunk, you don't have to drive a car. Now, you sit in the car and accident occurs. You may bring action against your friend for reckless driving or negligent driving. However, the court will not allow you to recover all the losses that you suffered because you are aware that the person is drunk, yet you sat in the car. By way of summary, through our discussion, we have been able to exhaust the concept, the standard of care as determined by the court, its components, and the defenses against this standard of care. Thank you and have a nice day.